And welcome once again, Employment Law Show. John Scholes along, Lior Samfiru doing the social distance thing still. And a reminder right off the top before I forget, not that I would, but covidrights.ca is a website you can check out anytime while we're doing the show or otherwise. It's open, it's free. Lots of information on there with it has to do with both disability, the other half of what your firm does, Lior, and employment as well. So covidrights.ca. You want to send an email along, help@disabilityrights.ca. And on the show today, pal, we're going to do wrongful dismissals during the COVID-19 pandemic. Lots of stuff on the show today, so stick around. Anytime reaching out, 1-855-821-5900 is a phone number as well. How are you, pal?
Hey, I'm doing well, John. I miss being in studio with you and the rest of the team there, but hopefully not we'll be able to do that. But it's been a very busy time for me. Really, all the teams, all the lawyers in my office, my whole team, we've been answering emails about the CRB, about EI, about other benefits, temporary layoffs. This is a very unique, very unusual time. And if there's ever a time when employment laws are important, man, oh man, it's right now. You really need to understand what your rights are. You don't want to sit on those rights, because if you do later on, you may significantly regret it. So if you want to know what your rights are, what you're owed, how much the government assistance can provide to you, what to do if you've been laid off or your salary's been reduced or your job is changing, maybe you don't have a job, any and all that, we try to cover on this show. But if we don't touch on your specific issue, reach out to me. You can call, you can email. We'll give you that contact information throughout the show. Take advantage of the fact that I'm available. I want to answer questions. Let's face it, I'm not doing anything else these days. I can't leave the house. So happy to answer all the questions that you have. Now, to kind of get started, John, week there was, let me tell you about a situation that really made me shake my head this week. This company should have absolutely known better. Talk about a large employer here. I'm not going to give you the name right now because really it doesn't matter, but it's a large employer. And they told their employees that we're going to have to give a 25% pay cut. And we're doing that, employees, because we want to keep you employed. We don't want to have to lay you guys off to end your employment. So we need you guys to take a pay cut. So, about 80, 90 people or so got that same letter. Okay, fast forward a few days, pay cut is implemented, 25% pay cut. Fast forward another 24 hours. So 24 hours after this pay cut is implemented, they get terminated. They're told, sorry, we have to let you all go. So this is after they were told them, you're going to take a pay cut so not to be terminated. But it gets worse. Now, the company that terminated them, they're saying, we're going to pay you severance, of course, but the severance we're going to pay you is going to be based on this reduced amount, reduced salary, 25% less. And that's when the calls to my office started flooding in. What do we do here? Is this right? Is this legal? Well, John, it's so wrong that I don't even know where to begin. All right. First of all, it's wrong to tell someone take a pay cut so that you can stay employed and then a day later let them go. That's wrong. It's wrong legally. It's wrong just from a human level. So right off the bat, that's a big problem. But beyond that, if you terminate an employee, you have to pay them their severance based on their total compensation. You can't take advantage of an otherwise illegal pay cut. So this company is doing it wrong. These employees have significant entitlements. And I wanted to remind everyone out there, number one, your employer, by the way, does not have a right to reduce your pay unilaterally, certainly anything over 10%. You can say no, and if they implement it anyway, that could be a constructive dismissal. And certainly, if you are let go, your severance has to be calculated based on your full compensation. Company can't take advantage of an illegal pay cut. So if you're ever in that situation, you want to understand your pay cut, is it legal? You've been let go, you want to understand if you're owed more, give us a call. In this situation, John, what this employer did was wrong on many levels.
You bet. We've seen that before and probably will continue to see that more and more as this COVID-19 pandemic carries on for sure. Reaching out, by the way, as Lior said, 1-855-821-5900. Disabilityrights.ca. That is the website to go to as well. Once you're there, you can search out past shows of this nature or our long-running radio show. We pull the phone calls from it, play them back here, and we talk about them. First call for today, pal, is coming up right now.
My wife got a temporary layoff notice in a firm that she's had 22 years of tenure with, and she's part of the sales force. They just said, you can take your holidays until that runs out, then we'll produce your ROE or, so you can collect unemployment insurance. We're uncertain when this thing's going to be over and when you will be able to come back. Is she losing out by accepting what they've told us?
It's interesting, right? Because usually they can tell you when to take your holidays generally, can't they? The employer.
Yeah, so let's start with that. May as well start with that. The easy part of that situation is the fact that your employer is allowed to tell you to take your vacation even if you don't want to. Obviously, most employers don't do that. They want you to take your vacation when you want to take it, but they're allowed to say you're going to take your vacation now, next week, a week of vacation. That's not going to make you happy, but legally they're allowed to do that. But the bigger issue here is the layoff itself. Now, once this lady is put on the layoff, this person's wife is put on the layoff, she can accept the layoff or she can treat that as a termination. And our regular viewers have heard me say this before, that a temporary layoff in most situations is actually illegal, including now during the COVID-19 situation, meaning you have a right to treat that as a termination and pursue your severance. So that's an option that she has. Now, the question then becomes, well, what does she lose if she doesn't do that, if she accepts this layoff? Well, the biggest issue that happens is that if she goes back to work, she gives the company the right to lay her off again in the future. So right now I said the layoff is illegal, but the second time they do it, it's no longer illegal because she allowed her employer to do it that first time. So that's a problem. So that's why she's losing. So the question, of course, becomes, well, if she doesn't want to proceed with the layoff, if she wants to treat this as a termination, how much severance is she owed? So rather than go through a big analysis, let's simply go to pocketemploymentlawyer.ca. Let's input that information and let's see what she's owed. So I took her information, I plugged it into pocketemploymentlawyer.ca, and you can see right there on the screen, she's owed up to 22 months pay. Up to 22 months pay is what she's owed, the severance that she's owed right now. So in terms of what she could lose, that's what she could lose. Up to 22 months pay. Now, you out there at home, you may not be owed 22 months pay. You could be owed less. You could be owed more. If you want to know how much you're owed in your situation, pocketemploymentlawyer.ca is your good friend in that regard.
Again, you want to reach out, it's employmentlawyer.ca or help@employmentlawyer.ca through email. We'll try to get some of those a little later on in the show, but phone call number 2 for the day is first.
I work for a call center for a telecommunications company. As you can imagine, we are absolutely insane right now. Everybody is trying to find a way to save a dime. People are not very nice or polite at this point in this world for whatever reason. When this first started, our company was saying, hey, you know what, if you need time, take the time, stay healthy mentally, physically. Now all of a sudden that is all dried up. They've increased our hours, threatening us, writing us up. When we're being wrote up for interpretive things, how legitimate are they?
It's a good question. I don't think we've ever had that question before.
It is a great question. And it's unreasonable for a company to put you in a difficult situation, change the game on you, and then complain that you're not doing a good job, right? It's not appropriate. So if their expectations are unreasonable, if the circumstances are such that you can't necessarily do what they want you to do, well, then you can't be disciplined for it. So my concern always when I hear about these situations, if an employer is disciplining you when they probably shouldn't be, is that what they're trying to do is build the case to terminate potentially for just cause. And you don't want that to happen. You don't want the company to build a case against you and then later say, look at all these warnings we gave you, now we can let you go for cause. So what you have to do, what this person has to do, is outline exactly why the expectations are not reasonable. Outline exactly why the employer is now change the game, change the job, change the nature of what they are doing, so they're doing their best to manage. Don't just be silent about it. If your employer has unreasonable expectations, say so and explain why. You don't have to be aggressive. You don't have to be nasty about it, but you have to explain in a direct way why you're in this situation and why it's unfair to discipline you. And in some situations, John, what your employer may be doing by changing your job, that could also be a constructive dismissal. And if you want to know if your situation is a constructive dismissal, or if you want to know if the company has just cause to let you go, again, you can always go to pocketemploymentlawyer.ca as well for that.
And the rule always applies if you are going to reach back and tell them why they're wrong. It's always got to be in writing every time.
If it's not in writing, it does not exist. It does you no good if you have a conversation with the employer, because later on there could be dispute as to what was said, who said what to who. So an email works great. Probably best option. If you need to say something, say it in writing. Have that record. Always helps.
All right, coming up here, wrongful dismissals during the COVID-19 pandemic. We will tackle that after a short break. In the meantime, 1-855-821-5900 is one way to reach out. And check out covidrights.ca as well. Employment Law Show's coming right back. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employment Law Show. John Scholes, Lior Samfiru. Wrongful dismissals during the COVID-19 pandemic, or in general, I guess, but now it's going to be really, really widespread. Get down to basics, I guess, off the top, Lior. What's a wrongful dismissal?
So a wrongful dismissal is a fairly broad term that encompasses a number of things, but it really ultimately comes down to losing your job without proper compensation. So usually the reason you were let go does not come into play so much when it comes to wrongful dismissal. It comes down to compensation. So probably the most common form of a wrongful dismissal is when someone is let go, just a run-of-the-mill termination, and they're not paid proper and full severance. In that situation, if someone is owed 6 months pay and they receive 3 months, that's a wrongful dismissal. But when it comes to COVID-19, a wrongful dismissal can happen in a number of situations. An example, like we were talking about earlier, is a constructive dismissal. You've been laid off temporarily. Your job was changed. Your hours of work have changed. You can treat all of those as a termination, and because you haven't received compensation, it's actually a wrongful dismissal. So that's a very common situation to happen. And I've spoken with many people that either have been laid off temporarily and want their severance, or because the company's decided that they're cutting costs and they were let go and they have not received proper severance. That's a very, very common situation. So if you're without work or without pay, if your job has changed, that could be a wrongful dismissal. By all means, reach out to me and we can discuss exactly what you're owed.
I understand the broad points as we sit here and do it on this show, every weekend. But if I'm just your average guy, how do I know? Is there a sniff test, like my spidey sense? How do I know if I've been wrongfully dismissed?
So number one, if your job has changed significantly, then that's probably right there a wrongful dismissal, or constructive dismissal, the same thing. Now, beyond that, if you simply have been let go and you're staring at that severance package, 90% of the time, John, it's a wrongful dismissal, because in 90% of the time, the employee is let go without proper and full compensation. The easy way to confirm this 100% is simply to go to pocketemploymentlawyer.ca. Again, it's pocketemploymentlawyer.ca. There's a severance calculator tool there that allows you to find out in seconds, for free, anonymously, how much you're actually owed and if you've been wrongfully dismissed. So if you've been let go, assume you've been wrongfully dismissed, only because 90% of the time that is the reality. But go to pocketemploymentlawyer.ca, verify that for yourself, and if you are owed more compensation, let's you and I chat so I can help you get what you're owed.
Let me ask you kind of a two-part question. How common are wrongful dismissals under normal circumstances and now, like during the COVID-19 pandemic?
So in the normal circumstances, John, like I said, 90% of the time someone that's been let go has been wrongfully dismissed. It really is very, very, very common. Now, these days, frankly, I've seen it happen even more often. Maybe it's because a company doesn't have the money or doesn't want to pay the person what they're owed, or maybe because they don't have the time to get proper legal advice to understand what they owe the employee. But virtually everyone that's contacted me since this COVID-19 virus started, when they've lost their job, the money offered to them, the compensation was inadequate. I don't think I've spoken with one person since COVID-19 started when they've been let go and that the package was fine. So chances are, right now, and always, not just right now, if you are let go, you're probably owed more. And I'm not talking about, well, you're owed another few $100s. I'm talking potentially a number of months' pay. It could be a significant amount. It could be in the tens of thousands, even more. So it is common, and you have to do the right thing and get advice, because what do I say? If you sign off on that offer, if you don't pursue your entitlements, that's it. It's done, and you can't go back when you realize a month later, oh, wait a second, they owed me another $50,000. Then it's too late.
You mentioned packages you've looked at and people you talked to. Is it difficult to resolve? Is it a real pain, or is it fairly simple?
And, probably the main reason where people don't contact lawyers, at least what they tell me, is, well, I don't want to engage in a long legal battle. I don't want to be talking to you, Lior, for months at a time. I get that. I wouldn't want to talk to me for months at a time either. So I understand that completely. The nice thing about employment law disputes, wrongful dismissal disputes, is that they resolve quickly. It's not a complicated process. Oftentimes, we engage the company in a discussion with a letter, and we can resolve that in a matter of a few weeks. That's what happens in the majority of these cases. So never be afraid of that process. This is not like, getting a divorce, which can get ugly and can take a long time and can cost a lot of money, and in other legal proceedings. When it comes to employment law and wrongful dismissal, the majority of the time, these matters resolve quickly, on good terms, and without a lot of conflict.
Okay, so you're watching us now, possibly listening to a radio show, and you think, okay, I've just been let go. I think maybe I've been wrongfully dismissed. How do you know?
Well, pocketemploymentlawyer.ca, good starting point. Again, there's a severance pay calculator tool there. You call me, you email me, you talk to another employment lawyer if you don't want to talk to me. That's okay as well, as long as you do something about your rights, about your entitlements. You want to grab a copy of your employment agreement, have it handy, your job offer letter, employment contract, employment agreement, whatever you want to call it, have a copy of it. If you don't have a copy, ask your employer for a copy. They'll give you a copy. The reason for that, in some situations, the employment agreement may give us some guidance as to what you're actually owed if you are let go. So an important document to have. But beyond that, reach out. And like I said, if it's 7 p.m. on a Friday and you don't think anyone's going to return your call, just grab your pocketemploymentlawyer.ca on your smartphone or tablet or what have you, and you'll find out in seconds exactly what you're owed.
Reaching out, by the way, simple. We put it up on the screen all the time, just in case. 1-855-821-5900. Help at employmentlawyer.ca. And employmentlawyer.ca, the website, is where you go to find the radio show, which we've been doing probably for almost 8 years now, and continue to do so. Call number 3 from the radio show. We're going to get it on right now.
I'm going to be placed on the CEWS, like the emergency wage, and effective tomorrow. I'm just reading over my agreements now. According to what I'm reading, it's saying that if for any reason the company does not receive the wage subsidy, and there's a bit in there that talks about you agree to these agreements and express you waive any claim, including but not limited to claim of constructive dismissal. So what does that mean?
What I want to know is whether they're going to still pay you 100% or they're only going to pay you 75%.
75%.
Sounds like the employer's making their own laws.
Look, they're not allowed to do that? What's wrong? No, they're not. So let's talk a bit about that and the wage subsidy as relates to this situation. So some employers now are applying and are going to be getting the wage subsidy, and that allows them to pay employees up to 75% of their wages, up to a maximum of $850 some odd in a week. Now, if that's what your employer is doing and they're topping you up to 100%, then there's no issue. You're still getting your full wage. But if your employer is saying, well, we're going to pay you, but we're only going to pay you the 75% that the government is giving us, well, the problem with that is now you're taking a 25% pay cut. And what do we call a 25% pay cut? I said right off the top of the show. Well, that's a constructive dismissal. Despite this wage subsidy, it doesn't change the reality that a 25% pay cut is not something your employer is allowed to do, and you can treat that as a constructive dismissal. and pursue your severance. Now, in this situation, what our caller was saying is her employer is trying to guard against that by saying, well, we'll do that if you sign this piece of paper that says you're not going to pursue a constructive dismissal. So practically speaking, if you have no intentions to pursue a constructive dismissal, fine, I guess you can sign it. Otherwise, you don't want to sign it. But here's the last point I'll make when it comes to these pay decreases. If you're going to take a pay decrease, if you're going to be that good soldier, and which is great, and take the pay decrease, make sure you send your employer an email saying, I'm only accepting this pay decrease for the COVID-19 situation. I am not agreeing to any future pay decreases, and I expect for my salary to increase back to normal once we're out of this COVID-19 pandemic. The reason you want to do that is because when you're out of the pandemic, you want your salary back. It's not assumed that just because now we're out of the pandemic, or we're going to be out of the pandemic, that your employer has to bump you back up to your old salary. No. If there was no agreement on that in the beginning, your employer can say, we reduced your salary, you accepted it, there was no deal that will bump you back up, now you're making less money. Don't let that happen. If you're going to take a pay cut, send an email telling your employer you're only agreeing for a limited time and that you expect to get paid back in full as soon as possible.
All right, coming up here, we'll take a short break. Quarantines and your employment rights. We'll get to that after a short break, as mentioned. 1-855-821-5900 and employmentlawyer.ca. It's the Employment Law Show. Stick around.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Live Show. Yeah, do what that guy in the voice just said, employmentlawyer.ca. That's where you want to go. That is the website. There you will catch a link or several links to our radio show. And we take a ton of phone calls because we're busy on that show as well every week for the past 8 years. We like to play some, we cherry pick some of the phone calls from the radio show, Lior, playing back here because they show some good employment law evidence. We'll get to the, fourth call for the day right now.
When this whole thing kind of started, I took a day off work, wasn't feeling good, and when I went to come back, they wanted me to take my 14 days quarantine, so I did that, and then I was supposed to go back after the 14 days, and then I got a text message from my boss saying, due to safety concerns, I can't come back right now, I have to go in and get tested. I did get a note from the doctor, submitted it, it wasn't good enough, so I got a call saying they want their phone back, their keys back, so they basically fired me, they won't come out and say it. I worked there for just over a year. I am 39, and I'm a foreman.
Gee, thanks, boss. Nice.
So, and that's called way overdoing it. And I understand, obviously, the need to be careful. Of course I do, and every employer should be careful. But just because someone takes a sick day and then they're cleared to return to work from their doctor doesn't mean that the employer can or should go overboard by requiring all kinds of tests or all kinds of measures. Now, it's one thing if the employee clearly had the virus, then yes, they should get a test to be cleared. But this person took one sick day. The doctor says they're ready to come back to work. The company can't just decide to make up their own rules. Ultimately, like with anything else when it comes to your doctor gets that final say. If you're clear to return to work by your doctor, your employer can't impose additional conditions. They can't say, well, that's not good enough. We want something else. We want something more. If your doctor is clear, this is my patient. This person, I examined them. They're able to come back to work. That's it. That's all that matters. So in this situation, the employer should have allowed him to come back to work because he had that doctor's note, and which cleared him. So now that he wasn't brought back to work, he was terminated. And that's what we were talking about earlier. That's a wrongful dismissal. So he wasn't paid anything. So the question becomes, what is he owed because he's been wrongfully dismissed? So we'll go back to our good friend, pocketemploymentlawyer.ca, and we'll plug in his information. And we'll see that in his situation, given his years of service, even though he's only been there for 1.5 years, he's not an old guy, he's only 39 years old, but even in his situation, he's owed somewhere between 3 to 4 months pay. You can see that right there on the screen, 3 to 4 months pay. That's because he was let go. That's a termination. His employer did not have a right to decide he's not coming back to work. And the same thing happens with you. You may be a short service employee. If your job is terminated, if your employer won't let you come back to work, if your employer imposes conditions that make no sense, you could treat that. That is a termination. You're owed severance, and even after a year, just like this person, easily could be owed 4 months' pay.
Again, you want to go to another resource to ask some questions when we're not on the air. Maybe we'll talk about your questions in a future show. Terminationquestions.com. Again, terminationquestions.com. You can go there and put your questions in, get them answered by Lior, a member of his crew. One for today, pals, this. Cal writes in, says, my employer just told me they no longer afford my services. However, the company is actually generating more business because of the pandemic. When I asked about severance after 4 years, they said they don't owe me anything because I was a contractor. Is that true?
Wow. Well, I don't know that we can do a show where I can spend a day in the office without having to deal with the issue of employee versus contractor. It happens so often. Now, this is a fairly brief question, so we don't have all the information. But, John, chances are, after 4 years, that this person is not a contractor. Nonsense. You don't work somewhere 4 years, especially if you're working regular full-time hours and are a contractor. He's likely considered by the law to be an employee, and that's a common situation. We have hundreds of people, I assure you, watching us right now, who are exactly in that same boat. They believe that they're contractors, but the law makes that determination, and the law decides, no, they really are employees. And why is that important? Well, it's important for many reasons. Number one, you could be owed vacation pay and overtime pay and holiday pay and overtime, etc. But beyond that, in this particular situation, if you are let go and the law considers you to be an employee, you're owed severance. So this person, after 4 years, could easily be getting 6 months' pay or even more. So it's not a situation where the employer can avoid paying what they owe by calling someone an independent contractor. Think about it, John. If it was that simple, well, everyone can be called an independent contractor, and then there would be no such thing as employment laws. It doesn't work that way. If you look like an employee and you act like an employee, you are an employee.
We'll get to one more here before we wrap. Again, terminationquestions.com. Miriam says, we were just handed new employment contracts and asked to sign them by next Friday. Our company is still up and running, but who knows what will happen over the next few weeks. Do we have to sign this new paperwork?
Well, the short answer is absolutely not. There is no reason for you to have to sign a new employment agreement when you're not starting a new job. You already are employed. And why is the company going to ask you to sign? Well, they're going to ask you to sign because that piece of paper that they want you to sign provides the employer with better rights and better entitlements than they have already. So it takes entitlements that the employee may have and gives them to the employer. So it's always a bad idea to do that. Now, what can those things be? Number one, it could be things that allow the company to let you go with minimal compensation. It could be a term that allows the company to reduce your pay. It could be a term that allows the company to change your job or change your location or lay you off temporarily. All those things that an employer does not have a right to do unless you sign an employment agreement that gives them that right. So if you're already employed and your employer comes to you and says, I want you to sign this new agreement, even if they say, oh, it's because of COVID-19, I don't care if that's what they say. It's still a problem. Do not sign anything. At least let me review it first. Let me figure out what it actually says and whether you should be concerned. But the general rule is you do not have to sign an employment agreement once you're already working. You cannot be penalized for it. And in most cases, you don't want to sign it because you could be giving up your rights.
And if you do sign it and they don't give you anything for it, it doesn't hold water anyway, does it generally?
Generally, yes. If you're already working and your employer wants you to sign a new agreement, they have to give you something in return for that to be legal. If you simply sign on a piece of paper but don't get anything in return, it's probably not enforceable. But the best advice is let's not even get into that dispute. If you don't believe that something is appropriate, if you don't think that something should be signed, don't sign it. It's never a good idea to sign something so that later we can say now it's not enforceable. Ideally, just do not sign it.
All right, we are done for another week. Good stuff. You want to reach out, 1-855-821-5900. Help at employmentlawyer.ca and covidrights.ca. That's a website you're going to want to use as well. And you can check out anytime Pocket employmentlawyer.ca as well. Thanks for watching. We'll see you again.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.